in the Capitol to have a bipartisan hearing with a consensus panel in a bipartisan series that is building towards a piece of bipartisan legislation that the witnesses have the outlines of anyway, and we'll try to refine so that we can file them shortly. I want to express my particular appreciation to Senator Kennedy and his team for the work that we have done to address the procedural logjam that is hindering Congress's oversight of the executive branch. We are trying to avoid making this a partisan issue. It is not. It is an institutional, structural matter, and we need to fix it. I would like to put into the record the bipartisan report that Senator Kennedy and I put out a little while ago that I don't think has yet been made a matter of committee record. And today's hearing starts where that report leaves off. The three witnesses are here to review solutions to the problem. So let's review what the subcommittee has learned so far. First, we heard from multiple experts that the old traditional way of resolving oversight disputes between the two branches has collapsed, is not working anymore. It was called the Accommodation Process. And through that accommodation process, Congress and the executive branch used to be able to find compromise when Congress wanted information that the executive branch didn't particularly care to turn over. The Reagan memo explained the process. The rule was that the president would withhold information requested by Congress on executive privilege grounds only after accommodating Congress's requests, quote, to the fullest extent possible, and, quote, only in the most compelling circumstances. The process was that the Department of Justice's Office of Legal Counsel would act as ombudsman to fairly weigh Congress's information needs against the executive branch need for confidentiality. This process has broken down. The executive branch increasingly asserts extreme and exotic theories of executive power to deny Congress access to the information it needs, often pursuing arguments that fly in the face of what courts have actually said about our oversight authority and executive privilege. The executive branch, with OLC leading the way, has built and inhabits a parallel legal universe from what exists in Article III courts. Last fall, the subcommittee invited Christopher Schrader, the Assistant Attorney General in charge of OLC, to appear and tell the executive branch side of the story. It was the first time in 20 years that a sitting Senate-confirmed head of OLC had testified before Congress. Mr. Schrader committed to working with us to fix as many of these problems as we can, but it was clear that OLC and Congress do not see eye to eye on these issues. Without OLC as a neutral and trusted intermediary, Congress has to ask courts to intervene. But under current procedures in court, delays obtrude. Litigation can take years, and the executive branch has multiple tools at its disposal to run out the clock. The executive branch has even perpetuated the notion that all requests from Congress expire at the end of each Congress, leaving us with congressional oversight Groundhog Day. Imagine how that can stall court proceedings. As a district court judge, now Supreme Court Justice Ketanji Brown Jackson wrote an opinion dismantling OLC's theory of absolute immunity and ordering a former White House counsel to comply with the House subpoena. But that decision went up on appeal. The D.C. Circuit debated whether the House could even go to court in the first place. After 2 years of back and forth, that litigation ended with no final resolution of who had the better view of the law, and Congress did not get the information it needed until after it was too late to use it. So today, the subcommittee will be considering legislative solutions to these problems. The obvious premise for reform is that there be a truly neutral arbitrator and an expeditious procedure. Given the exotic theories offered by the executive branch, perhaps even the mere threat of a binding Article III opinion timely could facilitate moderation. but only if courts can mediate these issues without protracted delay. That is a function that courts are well equipped to serve. They serve it in other functions. And to the extent that courts need better tools to hear these kinds of disputes efficiently, well, that's what our bipartisan bill would be intended to achieve. Our witnesses today will help us think through the steps Congress can take to address executive branch contumacy and to restore meaningful accommodation between the branches on these questions of executive privilege. Turn now to our distinguished ranking member.
Thank you, Mr. Chair. I'm not just saying this because he's here. Senator Whitehouse is a deep thinker, and this bill is the product and the evidence of that. He's done a lot of work on this bill, and he came to me with this idea, and I leapt at the chance to work with him. I think any fair-minded person would have to agree that our founders wanted to create three separate but equal branches of government. The problem is that the United States Congress, almost since its inception, has given away a lot of its power, in my opinion. We've given it away primarily to the executive branch, of course. The administrative state is part of that. Some of that was I'm not suggesting it was all wrong or inefficient, but some of it was. I've served under or with two administrations, one Republican, one Democrat. They're both act the same in terms of the privilege. I don't blame them. I mean, if I see their point of view. They think they're right, and Congress is wrong, and they have their objectives, and they see Congress sometimes as an obstacle. And when we ask for information, they say no, and we say, pretty please with sugar on top, and they say no. And then we get firm, and they say, sue me. And by the time we get it worked out, we've forgotten why we asked for the information. I think Senator Whitehouse's bill is fair. I think it's fair to both sides. I think it emphasizes the need for neutrality, as well as the need for what I call the time dimension. I mean, we need answers on this stuff. And it is a bipartisan issue. And I will tell you, I do think that if we have the time to present it to our colleagues in the Senate, they will vote for this. We get an overwhelming vote, and I think we can pass the House. It's just not a partisan issue. I want to apologize to you. I'm going to try to get back. I've got a group waiting in my office and another subcommittee here, but I want to try to get back as well. And I'm so thankful too to my friend from Hawaii that she is here today as well. So thank you all for being here, and I'll try to get back.
Thanks, Senator Kennedy. While you're still with us, I think I'll just add one additional comment, which is that you and I have probably both had the experience in our lawyering lives of parties appearing in court with dramatically different views of what the law is, and spending some quality time with the federal magistrate before the matter goes to trial and before the major motions get filed, and the salutary effect of that magistrate to bat away the more eccentric and exotic ideas and to try to make sure the parties understand what this is really going to look like when it comes to trial can be a very powerful and healthy force, and that's sort of the general model of what we're trying to replicate here. So with much appreciation, Senator Kennedy, I know you have other hearings and people at your office, and I hope you have the chance to return. But I will turn now to our witnesses. Sean Stiff from our Congressional Research Service serves as legislative attorney in the American Law Division. CRS provides nonpartisan research and analysis to help Congress with our legislative and oversight responsibilities. Mr. Stiff has published numerous reports on constitutional law and congressional power issues. The Honorable James Townsend is the director of the Carl Levin Center for Oversight and Democracy at Wayne State University, which is named in honor of my former colleague and dear friend, the late United States Senator Carl Levin of Michigan. I was at Naval Station Newport the other day for a change of command ceremony, and as I stepped onto the ship and back off of it, I noticed that the ship right in front of us was none other than the USS Carl M. Levin. Mr. Townsend served as a member of the Michigan House of Representatives, as a legislative director for Congresswoman Nita Lowey, and as a staffer for U.S. Senator Frank Lautenberg. Mark Rozelle is the founding dean of the Schar School of Policy and Government at George Mason University, where he holds the Ruth and John Hazel Faculty Chair in Public Policy. He has written a book, Executive Privilege, Presidential Power, Secrecy, and Accountability, and has previously testified before the subcommittee in 2021 about Congress's oversight challenges. I'm delighted to have you all back. Please proceed with your opening statements. We'll start with Mr. Stiff.
Thank you, Chair Whitehouse, Ranking Member Kennedy, and members of the subcommittee. My name is Sean Stiff. I'm a legislative attorney with CRS's American Law Division, and I'm honored to testify today on executive privilege, testimonial immunity, and the accommodations process. Information disputes between Congress and the executive branch can draw into conflict two implied powers. The first is Congress's power to inquire. This power allows Congress to compel the production of information in aid of the legislative function. The second power is executive privilege. This is the president's interest in confidentiality that relates to the effective discharge of his powers. The Supreme Court has recognized the privilege with respect to certain national security and diplomatic information, and also with respect to the president's personal communications. The executive, though, argues that it extends further to other types of information, including deliberative and law enforcement materials. But Congress has resisted these extensions, at least when it comes to a congressional subpoena. The executive claims a related but distinct shield called testimonial immunity. According to the Department of Justice, Congress cannot compel the president to appear and give evidence because that would undermine his autonomy as a separate branch. DOJ also argues that Congress may not compel evidence from senior presidential advisors because they are the president's alter egos. Once again, Congress disagrees. Now, conflicts between the two branches over information access have occurred since the founding. In 1796, for example, President Washington declined to share the instructions that he had given to John Jay, his American negotiator for a treaty with Great Britain, citing confidentiality interest. But these disputes with the executive did not involve the federal courts until 1973 during the Watergate affair. And even today, 50 years on, we can count on one hand the number of cases that have produced a merits ruling on an incumbent president's assertion of either privilege or testimonial immunity. In the earliest example, a Senate committee failed to offer a strong enough case to overcome the privilege that attached to the president's tape-recorded conversations. Almost 40 years later, in litigation over Operation Fast and Furious, a district court agreed with DOJ that it could raise the deliberative process privilege in response to a congressional subpoena, but in that case, the House was able to overcome the privilege. In the two cases that address the merits of a testimonial immunity claim, two district court judges, including future Supreme Court Justice Ketanji Brown Jackson, rejected the executive's theory. In these few cases, committees have secured wins but suffered losses. They've encountered delay that arguably favors the executive branch's interest in maintaining the status quo. For example, 2 years passed before the two witnesses who asserted testimonial immunity appeared for interviews. And in those cases, it wasn't court orders that resulted in those interviews, but rather it was the accommodations process. Now, this is a flexible process that sees, when it works, Congress and the president reach a negotiated compromise. It's not a rules-based process, but the DC Circuit has suggested that it has constitutional roots. On this view, the framers used general language to allocate powers between the branches because they expected a spirit of dynamic compromise between the branches. Compromise in this view would solve interbranch disputes and advance the constitutional design. As with many negotiations, a party's bargaining power depends on their likelihood of success in litigation, but it also depends on the leverage that can be brought to bear outside of litigation, and Congress has several options in this respect. It can refuse appropriations, curtail statutory powers, withhold Senate consent to nominations and treaties, hold executive officials in contempt of Congress, and wield the impeachment power. It is difficult to assess in general whether the D.C. Circuit's expectation of dynamic compromise occurs in practice. So much depends on the facts of a particular dispute, the privilege at issue, each branch's assessment of its likely success in litigation, and the risk that it is willing to accept of a bad result in litigation. But at bottom, the accommodations process is about the exercise of leverage. So perhaps the most important factor is Congress's willingness to use its other legislative and political tools. I welcome your questions.
Thanks very much. Mr. Townsend, please proceed.
Thank you, Chairman Whitehouse, Ranking Member Kennedy, Senator Bruno, and the members of the subcommittee for this opportunity to comment on restoring transparency and accountability in the accommodation process. My name is Jim Townsend, and I'm the director of the Carl Levin Center for Oversight and Democracy. I'm here today on behalf of the center, which is headquartered at Wayne State University Law School in Detroit. Our mission primarily is to support and promote bipartisan fact-based oversight in Congress and the 50 state legislatures. Many of you on this subcommittee, as the chairman noted, served with our founder and namesake, the late Senator Carl Levin. And you are personally aware of his deep commitment to Congress's ability to obtain information, the information it must have in order to represent and act on behalf of the American people. There are many times over his 36-year career where he battled with the executive branch, regardless of who was president, over access to information. Most of those encounters were resolved through negotiation and at times included the recognition on his part of executive privilege. But in the end, he worked hard to make sure Congress got what it needed to act in an informed manner. My colleagues and I at the Levin Center are honored to carry on, to the extent possible, his remarkable legacy. Before becoming director of the Carl Levin Center, I spent over 30 years in various roles in the public and private sector. As the chair noted, I was a congressional staffer in both the House and the Senate. I was a product planner and marketer in the automotive industry. I have worked in private practice in law, and I've served as a member of the Michigan House of Representatives, where I was vice chair of the Oversight Committee. In all of those roles, access to accurate information was absolutely essential to doing my job. Obviously, the same thing holds true for members of Congress, which makes it all the more remarkable that in the last few years, really quite a few years now, it has become increasingly difficult for the legislative branch to get the information it needs from the executive branch. This subcommittee has done the nation a service by delving into the reasons why and what can be done about it. I'm going to spend the balance of my opening statement summarizing some options that the Levin Center recommends be taken. Those options are available for you in my testimony and then summarized in exhibit number 1 at the close of my testimony. In terms of strengthening civil enforcement of congressional subpoenas, we recommend that Congress consider legislation and perhaps House and Senate rules that fall into 3 categories. Number 1 is codifying better civil enforcement. Number 2 is authorizing new penalties to deter noncompliance. And number 3 is streamlining judicial review. There are also a few other ideas I'm going to mention at the end of my testimony that can also improve, strengthen Congress's position, and in so doing, improve and revitalize the accommodation process. So just to summarize our ideas, and again, these are ideas that come from a number of places, but these are the ones we think are the strongest. Codify Congress's civil enforcement powers. There's a need for legislation to explicitly authorize Congress to file civil actions to enforce subpoenas. There are several measures introduced in the House that do this. The ones we've seen need to be amended, though, to specifically cite the power of Congress to bring civil actions to enforce subpoenas against the executive branch. Such measures should establish rules and timelines for how the executive branch should respond to subpoenas, and they should address abuses to executive privilege by requiring that only the president may assert the privilege. It must be in writing, and it must be accompanied by a privilege log. Another area of opportunity for Congress is to enact civil penalties to deter noncompliance with congressional subpoenas. This involves establishing by statute civil fines and possibly detention for noncompliance with congressional subpoenas. You might consider the issues that are raised by either having Congress enforce on its own or go through the courts. There are a number of issues. You've got a balance in that. But I think the important thing for you to recognize is that you're going to be, whatever happens with these kinds of fines or penalties, they're going to be adjudicated in court. Finally, streamlining judicial review. It's very, very important that Congress takes steps to streamline judicial review, to make clear that the courts need to give this a priority and that they need to create a set of regulations to streamline the process. There are a few other ideas, but I'll bring those up during questioning. Thank you.
Thanks, Mr. Townsend. Dean Rozelle.
Thank you, Chairman Whitehouse, Ranking Member Kennedy, and members of the committee for the invitation to address the current status of executive privilege. I am Mark Rozelle. I serve as the Dean of the Schar School of Policy and Government at George Mason University, and I've been writing about this topic for a good 3 or more decades. And I've observed how presidents increasingly have claimed unbreachable executive powers not subject to negotiation and compromise. Our system of separated powers has long depended on an accommodation process in which the executive and legislative branch officials work out compromises that serve the needs of both, as well as the public interest. Executive privilege, though, has always operated in a constitutional gray zone in which the normal give and take of the system of separated powers struck me as a far better approach than imposing some firm rules which can never anticipate all future scenarios. In the past, I have rejected calls for either a legislative imposed definition of executive privilege or empowering the judicial branch to routinely settle access to information disputes between the political branches. In 2021, I testified to this committee that I doubted the utility of the judicial branch being empowered to intervene and settle executive privilege disputes before an accommodation process between the political branches can take place or have enough time to work out some compromise. I applaud the work of the committee to address the need for a solution to resolving executive privilege disputes, given the breakdown of the accommodation process, which has largely been due to unyielding executive branch strategies to resist Congress's oversight and investigative functions. The report over privilege makes a strong case that the accommodation process simply is not working, that chief executives of both parties have adopted an expanded definition of executive privilege and have engaged in a kind of brinksmanship strategy of even daring Congress to employ its constitutional tools against the executive. An executive tactic of resist, obstruct, and delay has worked in effect to run out the clock on an administration before a dispute can be resolved. Underlying these trends is the intensifying political polarization in which partisan considerations too often override protecting institutional prerogatives. The very structure of our separation of power system advantages presidents in this environment. The unity of the executive assures that presidents will always defend executive powers without having to navigate internal dissension. Congress, of course, has never had such unity, and contrary to the expectations of our constitutional framers, the legislative branch has often failed to defend its institutional powers against executive overreach. Congress is now beset by intensified partisanship that collective action in defense of its prerogative seems more unlikely than ever, thus the need for some action. So like many, I lament the decline in government of the spirit of comity and cooperation that were the hallmarks of the accommodation process, but pleading for a return to the good old days is not a solution. Presidents and even ex-presidents have become increasingly bold in their claims and unyielding to Congress. Congress's constitutional and political tools are not working effectively to push back. The report also raises the question of whether it's time for reforms, and I agree that Congress should not abandon its traditional tools. It should strengthen them, and I think adding a new tool such as a congressional counterpart to the Department of Justice Office of Legal Counsel would be a very positive step to counter the tendency of the executive branch and oftentimes courts and legal scholars to cite OLC opinions as binding legal precedents. These actions seem the most achievable in the near term, What will be challenging is those ideas that would empower the judicial branch to resolve executive privilege disputes through mediation and ultimately litigation should that process fail. Senators Whitehouse and Kennedy suggest specifically a mediation role for the U.S. District Court of the District of Columbia. Whether such a reform is workable depends on a number of factors, and I raise these as considerations and not as a criticism. Do judges want to be invested with the authority to mediate information disputes between the political branches? Judges likely will refuse to mediate in disputes they deem to be political in nature and therefore not subject to constitutional standing. Judges might push back on calls for mediation, declaring that the two branches have to battle out their differences that they should be capable of resolving on their own. Indeed, federal judges have demonstrated little interest in resolving disputes when presidents refuse to divulge information to Congress, and judges may also be concerned about issues of workload if the other branches increasingly are in tussles over access to information. As many information disputes involve large reams of documents, it's hard to imagine that any court having the capacity to review and render meaningful guidance in circumstances in which the White House claims some compelling national security or protecting state secrets basis for withholding documents. I also caution against the expectation that the judicial branch will favorably mediate appeals for executive branch information. The judicial branch has given great deference to the executive claims of expansive powers in national security and foreign policy more generally. Many executive privilege disputes tend to have either an actual or presidential claimed national security component. Could this suggested proposal, in other words, become a careful what you wish for scenario in which Congress expected a better outcome than the current give and take process, but ends up conceding more power through judicial interventions that favor the executive and create precedents for expansive executive privilege power? Finally, the potential major benefit of this suggested reform could be the avoidance of protracted legislation between the political branches. The Trump years in particular were witness to an extraordinary number of lawsuits involving executive privilege claims. The decline of the accommodation process had already started before Mr. Trump's presidency, but during his term, it became almost routine that the president and the House of Representatives in particular filed lawsuits against each other over access to information disputes. If a reform proposal can overcome the conditions that have enabled presidents to resist, obstruct, and delay, it could ultimately deliver a mediation process in which parties agree to play by the rules. That will be a huge step forward in reestablishing some balance between the branches in executive privilege disputes. Thank you.
Thank you. Let me summarize where I think we are, subject to Senator Kennedy correcting me in some fashion. But I think where we are is that we observe that these conflicts over access to executive branch materials to perform congressional oversight almost immediately come to loggerheads, and that in resolving these very significant disagreements, the role of OLC as a even remotely neutral arbiter has completely collapsed. Indeed, OLC has become something of a peculiar legal hothouse for exotic theories that don't survive scrutiny in Article III contests, even ones in which OLC and the Department of Justice have proposed those theories. And then in a rather truculent manner, OLC takes its defeat in the courtroom, goes back to OLC, refuses to change its opinion, and pretends that its defeat never happened and stands by its exotic hothouse theory. So where we are right now is completely untenable. And I think as those of us who've had any experience resolving disputes and practicing law and managing trials know there's some pretty basic elements that move parties from loggerheads to a willingness to accommodate followed by an accommodation. The first is having some form of neutral opinion that both can refer to. You may agree, you may disagree, but there is a neutral opinion out there. In the case of federal court proceedings, that neutral opinion is very often provided by the federal magistrate who's looking over a case in the beginning and saying, come on, you guys. Second, that neutral opinion can't just be plucked out of a law school someplace or some source of opinion. It has to actually end up being a neutral opinion source that bears in some fashion on the dispute. And again, that suggests a court with a good early magistrate-type review that creates a reality check for the parties on the more exotic legal theories and at least narrows the dispute to within more rational and accommodation-centered grounds. The third consideration, neutral opinion that can be a real reality check. The third is that it has to be timely. If it's 3 years out, 4 years out, it doesn't matter. You've got to be able to get in and at least get that preliminary reality check pretty quickly. And the fourth observation is just, how many cases settle on the proverbial courthouse steps? Even when parties want to settle, very often it's only the eve of litigation that actually extracts the settlement from the parties. And when one party does not want to settle, then you really have no opportunity until the eve of litigation. So all of those things direct me toward the notion that the U.S. District Court, which is just blocks away, could be required to have a magistrate-type proceeding that either party can go to fairly early on in a dispute to get kind of a preview of coming attractions of where we think this is going to go, and look at the U.S. District Court precedent that OLC refuses to acknowledge when it's taking its positions, and help frame the dispute a little bit more narrowly. So that's where I think we are. And I'm hoping that we can continue to use the good offices of the witnesses whose testimony has been very helpful to refine this proposal enough that we can put it into legislative language and move forward. I saw a lot of head nodding from all of the witnesses through that description. I don't know that I've really formulated a question, but why don't I just turn it over to Senator Hirono, because my time is up, and when she's had a chance to ask her questions and engage with all of you, you've heard my thoughts. We can come back and have a little bit more of a more detailed conversation about where you see potential hazards and potential opportunities from a structure like that. I do think it helps to have it be familiar. I do think it helps to have it not be some new creation, some new office of interbranch intermediation of oversight or something like that. Everybody knows where the courthouse is. Everybody knows how magistrates and courts work. And to the extent that you can expedite the calendaring and have a place where particularly if the magistrate has been able to develop some expertise over some time so that they're actually kind of trusted and reliable to the parties, I think we could clear a lot of this nonsense out. Senator Hirono.
Thank you, Mr. Chairman. Well, it's pretty clear that the current situation is untenable vis-a-vis Congress's ability to get information from the executive branch. And when we start talking about the executive branch, the judiciary as being co-equal branches of government with Congress, when it comes to Congress's ability to exercise its own responsibilities and prerogatives to obtain information, the executive branch, as far as I'm concerned, aided and abetted by the OLC, has other ideas. So separation of powers doesn't work in a situation like this. So listening to all of you, I think we agree that the current situation it doesn't work because the so-called accommodation process is not even working when you have an executive branch that basically says, go fly a kite. And I do think that going to the judiciary is one of the ways that we can approach this, as long as there's not just a whole lot of delay going on. For example, the Don McGahn situation where he waited out the clock for some 2 years, that is not going to help this circumstance. So if I am I am still of the opinion that a judicial approach can work if we lay out the parameters and timeframes for that. And I also like the idea of Congress having its own OLC and our own ability to have this neutral entity, neutral in the sense that it's a counter to OLC. I like that idea that at least we have somebody on our speaking for the ability of Congress to get this kind of information. So we shall proceed under the leadership of our chairman. And I know that you have provided some suggestions. I would say a compilation of these various suggestions would probably be the way to go. And I look for your leadership for us to come up with a bill that will get us off the dime. Thank
Yeah.
you.
And I would only observe that the perfect can be the enemy of the good. But to quote Senator Hirono, the position we're in right now is simply untenable. I mean, we're in a worst-case scenario right now in which congressional oversight, which is very often described by very learned experts as a function of Congress as important and as significant as its legislative function, that one of the twin key functions of Congress has now been essentially completely disabled. And so while there may be some hazards and difficulties with some of the proposals, I guess I'll ask Mr. Townsend and Dean Rozelle, we're in about as, do you agree that we're in about as bad of a worst case situation as the country's ever experienced with regards to these disputes with the breakdown of the accommodation process?
Well, Mr. Chairman, I would say that
Your mic, I'm not sure is.
Is it on now? I'm sorry, I'm having trouble with the button. I would say that we are in a very bad place, a somewhat better place in the aftermath of the Mazars decision, which laid to rest some of the misconceptions about whether the federal courts have jurisdiction to adjudicate civil actions that are taken to enforce congressional subpoenas. So we're in a better place because of that. But we have a lot of work to do. I say the Congress has a lot of work to do to strengthen its position. The condition of the accommodations process is really a byproduct of a history where Congress has sort of had one hand tied behind its back without having an Office of Legal Counsel or some sort of mechanism to bring Congress together to state its legal opinions and provide a counterweight to the Justice Department OLC. We're in a position, Congress has been in a position where it has had provisions in law that have restricted the Senate's ability to bring civil lawsuits to enforce subpoenas that are brought to executive branch officials. That needs to go. There are no, there's nothing in law that says what the penalties are. There's nothing in law that makes it clear that the courts, that these actions have to be considered. So there's a lot that can be done. I think we should talk about the idea of mediation. I want to save time for my colleague, but I think there are a lot of things that should be done ahead of looking to mediation.
I agree.
I'm not at all interested. First of all, I'm not all that interested in penalties, just to be clear for the record of the hearing. I think resolutions and rapid resolutions so that we can get on with the business of governing are the key, and penalties should be reserved only for the most extreme contumacious type conduct, and that is not part of what Senator Kennedy and I are pursuing. It's a process that leads to a reasonably quick and reliable outcome, and that the prospect of which influences the behavior of the parties such that the more extreme and exotic positions that are taken fall by the wayside, and we get more quickly to the amicable resolution that is the, I think, ideal outcome, and the one that the court has indicated Supreme Court has indicated it would prefer. Dean Rozelle, I interrupted you.
No, that's fine. Senator, thank you. And I agree we're in as difficult a situation, I think, as ever with regard to issues of executive privilege in the accommodation process. I began my research on executive privilege back in the 1980s. My first book was in the early 90s. I testified in the early 2000s several times. I've observed a lot of these disputes going back and forth. And just as an example, during the Reagan years, there were multiple cases where the president claimed or threatened to claim executive privilege. Congress used its tools. There was a back and forth, and ultimately there was a compromise. And both sides walked away claiming victory, and they were able to move on. And so in my earlier research, I pointed out so many examples of where the process of give and take, negotiation, and compromise resulted in outcomes that were ultimately beneficial to the public interest. It wasn't a perfect process, and there were problematic situations and cases where it was not resolved perfectly. But I think we're in a very different situation now. Congress employs the tools that it has very vigorously to try to get access to information, and the executive is simply just saying, we are not willing to cooperate at all, take us to court, and just keep using all your tools, but you can't have it. It's been something of an evolution in my own thinking about this, because for years I had argued that the natural give and take back and forth in the system of separation of powers was the ultimate process for resolving these disputes, and that we didn't need a legislative definition of executive privilege or to routinely involve the courts in trying to resolve these disputes. But again, I think we're in a very different place now, and I agree that some reform, some action needs to happen.
Well, I had proposed to you that this is less about you changing your opinion than the terrain
Yes.
over which your opinion plays having changed. But Senator Blumenthal is just arriving. Let me ask Senator Hirono to ask her questions, then we'll turn to Senator Blumenthal. Give him a chance to get himself seated and organized.
Yes, thank you, Mr. Chairman. Dr. Rozelle, I agree with what I've heard here today, that mediation or expedited civil litigation is probably the way to go. But in light of the executive branch's refusal to enforce the criminal contempt statute against itself, I wonder about the need for something like an independent counsel as a last resort. Do you have any reaction to that idea?
That is one potential solution for sure, but the committee's also offering the idea of a kind of judicial entity, right, a mediator to take this role, and I agree that just coming up with a new office and thinking that you can magically find the neutral people who would populate that office and be able to mediate these disputes is extremely problematic. Look, I think every Congress should push the White House for its version of the Reagan memo. That was a good memo. It articulated the circumstances under which executive privilege would be asserted, the various conditions under which information would be turned over, and it said that the presumption was in favor of openness and that ultimately there should be an accommodation and compromise. So,
we did have an independent counsel from 1978 to 1999.
yeah.
And some of this, the accommodation process as being gradually changing, but I'm glad you mentioned the Reagan Office of Legal Counsel issued a series of opinions directing the U.S. attorneys not to enforce the 1930s criminal contempt of Congress statute against executive branch officials acting at the president's direction. So can you, this is for Mr. Stiff, sorry. Can you describe the criminal contempt statute briefly and what is required by its text and what OLC's 1984 opinion says about it? Because suddenly in this opinion, the U.S. attorney basically ignored the plain text of the criminal contempt statute.
Thank you for the question. So the way the criminal contempt of Congress statute essentially works is that there is a determination that an individual is in contempt of Congress because, having been served with a subpoena for documents or testimony, they, in the chamber's view, fail to comply with that subpoena. There is then a certification made to the appropriate U.S. attorney, so the local U.S. attorney, And the statute says that it shall be the duty of that U.S. attorney to present the matter to a grand jury for the consideration of an indictment.
Yes, shall.
Shall. So the opinion that you've referenced interprets that statute to retain prosecutorial discretion whether to pursue a particular prosecution, and also to not, they do not construe it as applicable in instances where an incumbent president has directed the noncompliance on privilege grounds.
So I'd say questioning that OLC series of opinions is another way to go, because, you know, that's when shall is not deemed to be shall. Thank you.
Thanks, Mr. Chairman. Thanks for having this hearing. You know, I've long been interested in the Office of Legal Counsel in the Department of Justice and the role that the lawyer in that office plays in interpreting statutes or constitutional law, and it's frankly often overweighted credibility that it provides, particularly in modern times where it seems as much the arm of the White House in some ways, or at least the administration's policy, and it gives credibility to policies that may not deserve it. And I think we've seen that a couple of times. Interestingly, there have been proposals for a congressional office of legal counsel that might operate effectively to protect the Congress and the separation of powers, our constitutional prerogatives, in the same way. I'd be interested in your views on the merits of a Congressional Office of Legal Counsel, and if you want to comment on the Justice Department's Office of Legal Counsel, I'd welcome that point as well. We'll go down the...
You want
to? So we at CRS are happy to provide objective, nonpartisan, confidential advice for members of Congress and committees. The Senate Legal Counsel and the Office of General Counsel in the House both represent those chambers in litigation, but there is not now sort of joint body that, outside of those contexts, prepares opinions that reflect the views of both houses.
And they don't issue opinions even there, do they? I mean, if you go to either your organization or those organizations, they won't opine without some kind of case or controversy, will they?
Well, so speaking for CRS, if a member or committee poses a question about law, we will provide consultation or written memoranda to address that and sort of interpret how Supreme Court case law, statute, and the Constitution bear on that question. But that is a product that we provide for you. It's not then endorsed by the chambers or adopted by the chambers.
Mr. Townsend?
I think it's fair to say that you know, a Congressional Office of Legal Counsel would be very different from the sort of the advice the CRS provides, as valuable as that is. There is no counterbalance that exists to the Justice Department OLC. What it appears you would get in a congressional OLC is you know, an office devoted to providing bipartisan, well-reasoned legal opinions that could provide a, you know, this is the view of the Congress legally on this question. With respect to oversight, it would provide, it would help build a set of norms, a set of expectations that Congress has for oversight for the enforcement of its subpoenas and other matters. And that would be a real power, or at least a counterweight to the OLC in the way it influences the accommodation process. So at the Levin Center, we don't believe, you know, we're not willing to, kind of sign off on the end of the accommodation process. We think it can be strengthened and revitalized, and an Office of Legal Counsel providing that legal advice, providing that kind of unity and the strength it can provide in negotiations can go a long way, we think, toward strengthening the accommodation process.
Mr. Rozelle?
I agree with much of what Mr. Townsend said. I think it's a great idea to have a Congressional Office of Legal Counsel that needs to be a counterweight to the Department of Justice, OLC. Unfortunately, so many of the opinions of the OLC are self-serving defenses of the executive position. They are not unbiased analyses of the issues of separation of powers that can help provide a path forward for resolving these disputes over executive privilege. So my advice to Congress is get started working on it. It's a great idea.
Thank you. And just to be clear, the Office of Legal Counsel's opinions are not judicially binding. They are not law, but they are often given tremendous weight by the president or by other executive branch agencies. They are regarded as law almost on many occasions. And I do think that a counterweight is needed because, as you've said so well, they're often self-serving, basically.
If I may just add, they also, you're absolutely correct, they don't carry the weight of law, but they do have an influence in the courts. And so, again, there's an imbalance here when you've got the executive branch with that entity on its side and Congress without it.
Thank you. Thanks, Mr. Chairman.
Thank you. One peculiarity about OLC is this business of propounding a theory, taking that theory into an Article III court, having the Article III court blow the theory to smithereens, not just losing, but really getting slapped down, and then going back to the office and pretending that none of that happened, leaving the theory exactly in place, and assuming that there's nothing that they need to do unless the Supreme Court has decided the matter, when pretty much all of these things would ultimately go back and be litigated before those very same courts. It's pretty supremely peculiar. Imagine a legal counsel taking a policy for a major corporation, proposing that policy in the relevant court of jurisdiction and venue, having that policy blown to legal smithereens, and then coming back to the company and saying, well, let's just keep doing it, because what the heck? So it's really unfortunate what's happened at OLC, but relevant to this, the real problem has been that there is no longer any basis for trust on the part of Congress in the neutrality of the OLC in its former role as an ombudsman or arbiter. So we have to go someplace else, and if we're not going to make up some peculiar new Office of Interbranch Comity or whatever, we've got a perfectly good court right down and it's going to end up in court anyway, because whatever the political dimensions of these contests might be, those political dimensions play out against a framework established by law, by courts and by law. And so we're going to try to solve this. I'm hoping that our next gathering on this subject will be another bipartisan gathering, in this case to do a markup of a bill that looks very much like what I've just described. I want to thank Mr. Stiff and Mr. Townsend and Dean Rozelle for their participation. We look forward to continuing to work with you as we put the fine-tuning and legislative language together for a bill. And with that, the hearing is concluded. Thank you.